Good afternoon, ladies and gentlemen, and welcome to the Licensing Subcommittee hearing. Councillor M. Cuthbert, Councillor Mrs Davies and Councillor Russell are forming the subcommittee, and members have nominated Councillor Cuthbert to chair the hearing. Councillor Cuthbert, can you please continue?
Thank you, Mr. Bourne. Miss Olivia Davies is our legal representative this afternoon. Please, can you remind the subcommittee of its administrative function and explain the procedure to be followed?
Thank you, Chair. I would advise members and others present for this meeting that in dealing with the business of the subcommittee, members will be exercising an administrative function with the process similar to the Magistrates' Court. The proceedings will be informal and the rules of natural justice will apply. For the benefit of those present, I will outline the procedure to be followed in dealing with the agenda. The Chair will ask all parties to introduce themselves. The licensing officer will then introduce the report in relation to this hearing. Members may ask questions on the report and other parties may also ask questions. The Chair will then invite any other persons present who have made representations and wish to speak to do so. Members and other parties may also ask questions of any other person who makes representations. The Chair will then invite the applicant to address the subcommittee. Members may ask questions of the applicant. Other parties may also ask questions of the applicant. There will then be an opportunity for the licensing manager and the applicant to make closing statements. Members will then leave the meeting to consider their decision and may request legal advice during their discussion. When members rejoin the meeting, they will give that decision. The decision itself will be confirmed in writing with reasons within 5 working days following today's meeting.
Thank you, Ms Davies. Item 3, declarations of interest. Are there any declarations of interest to be made at this time? No? Okay, thank you. Before I ask the licensing manager to introduce the matter before us today, could I ask all persons to introduce themselves, starting with the licensing officers?
Good afternoon, Chair, members, ladies and gentlemen. I'm Dave Leonard. I'm the Licensing Officer of Brentwood Council.
It's Paul Adams, Licensing Manager. I'm Chairman of Hutton Football Club.
I'm Darren Hall, Vice Chairman of Hutton Football Club.
I'm Steve Clark, Club Secretary.
Zoe Borman, I'm a clerk today.
Olivia Davis, Legal Advisor for the subcommittee.
I'm Councillor Will Russell, Rises, Don Matty and Southwold.
Councillor Martin Cuthbert, Worley, Chair for today.
Councillor Vicky Davis, Pilgrim's Hatch Ward.
Councillor David Worsfold, Councillor for Shenfield Ward and resident of Chelmsford Road.
Thank you all very much. Item 4. Application for a new premises licence, Hutton Football Club, Flint Community Hub, 154 Chelmsford Road, Shenfield, CM15 8RT. Mr. Leonard, will you introduce the matter, please?
Thank you, Chair. As you've put out, it is the Flint Community Hub at 154 Chelmsford Road. Mr. Peter Bowen has made their application on behalf of Hutton FC. Whilst there were no representations received from responsible authorities, the licensing office has received 8 representations in opposition from other persons. Additionally to that, the applicant has agreed a number of conditions with the police should consideration be given to granting the licence. But to go back into this one, obviously it's an authorisation in order to sale of alcohol, supply of alcohol, regulated entertainment, and to take into consideration the 4 licensing objectives, which are prevention of crime and disorder, public nuisance, public safety and the protection of children from harm. Now, the application is, it was received on the 13th of October from Mr. Peter Bowen for a new premises licence. A copy of the application together with a layout plan is attached to Appendix A. Now, Flint Community Hub is a football clubhouse comprising of players and officials changing rooms, toilets, kitchen, clubroom and a bar. The building is adjacent to football pitches and has a viewing area constructed from a wooden decking. A copy of the OS street maps to better identify the location is attached to Appendix B. Although I did a couple of visits to check the notices and ensure that all the advertising correct, each occasion I went, unfortunately the grounds are all locked up, so I couldn't access it to see the front of the building or give any additional images for you, which might better let you see how it relates, other than the fact it's a porter cabin, a large porter cabin. In regards to this, the application is seeking the following licensing activities: the supply of alcohol on premises from 11 a.m. to 11 p.m. Monday to Friday, 10 a.m. to 11 p.m. Saturday and Sunday, and the playing of recorded music from 8 a.m. to 11 p.m. Monday to Sunday. As I said, in addition to that, the applicant has made a number of undertakings which at 1.9, should you consider granting a licence, there will be a number of conditions added which, if added, the police have got no problems with the application. Additionally, in addressing the protection of children from harm, the applicant undertakes that all trustees and team management volunteers are required to attend regular safeguarding and welfare courses run by the governing body along with regular DBS checks. As I said, no representations have been received by any other responsible authorities. No environment, health, no planning. 8 representations from 5 households against the application have been received from other persons living in nearby proximity to the clubhouse. All representations raise concerns relating to the potential for noise nuisance and antisocial behaviour occurring with the introduction of alcohol and music to a porter cabin structure initially constructed to facilitate youth team football activity. The representations appear to follow on from what was an earlier disputed planning application, where again the concerns raised was the address close to the proximity of the clubhouse and neighbouring properties and the disruption the potential extended hours of licensable activity may cause to the residents. A nearby resident also fears that extended hours of supplying alcohol may increase antisocial behaviour and vandalism. A nearby household also cites that noise pollution will occur from the extended opening times, which will threaten the current peace and quiet of the neighbourhood and will consequently affect their quality of life. In respect of these representations, Chair, they are attached to Appendix D. I've then attached a number of guidance paragraphs from the Statement of Licensing Policy, which you may wish to consider in respect to this application, followed on from relevant sections from the Secretary of State guidance. That is more or less it, unless I can advise you with anything else in regard to that. Thank you.
Thank you, Mr. Leonard. Do members have any questions of the licensing officer at this point? No. So I do just have one question around the planning side of things. Obviously, this is a licensing matter, but there's a lot of planning issues that have been brought up. Are you able to clarify for everyone? It's essentially just, you know, you have half mentioned it, but you know the aspects that we should be considering, and how the planning or how any of the planning issues affect any of this.
Yes, in respect of that, as you look on the application or the representations, they do seem to mirror what appears to be representations that relate to a previous planning application. I have made attempts to speak with Mr. Bowen, a very amiable fellow, on the phone during the course of the consultation period, just to see if there was any leeway in regards to what's being asked for and what they actually want to achieve, their goals with the club. And it's my understanding that they may offer an alternative set of hours. I'm mindful that they don't want to be breaching planning conditions, but as you quite rightly say, planning legislation doesn't interact with licensing incredibly. They are a consulting authority, responsible authority, but it doesn't seem to sort of cross over with regards to representations because they've got their own legislation to follow up on. So again, there is a query with regards to this in as much as planning have provided us with the result of the planning decision, which again, working with Hutton FC, was closing times at dusk, which Mr. Bowen has said with it, But as I said, with regards to that, that is totally different legislation and doesn't address the full licensing objectives for which we're here today.
That's lovely. Thanks very much. Just good to get some clarity. Thank you.
Sorry.
Sorry, just to add to that, just for clarification, I think Dave has alluded to that. I think the function of planning and licensing are very different. The decision that you make today shouldn't have regards to the planning application. If you grant a licence today, not tonight, it's still daytime, it doesn't necessarily mean that it's lawful for that business to operate for those hours, because obviously you have to get the rest of the permissions in place. It's just one step in a process to receiving, being able to lawfully operate a business. So you shouldn't have regard to any of the planning matters because they don't relate to one or more of the licensing objectives.
Lovely. Brilliant. Thank you very much.
Question on that.
Yeah, Councillor Russell.
So, just to clarify the matter further, who would be enforcing? Would it be planning or would it be the licensing if they were operating outside of those hours? Thank you.
If they operate outside of their planning permission, then that would be planning to enforce. If they operate outside of their licence permission, that would be for us to enforce.
Sorry, I guess it could also apply to both technically at some point in theory, and so it could be both at that point.
Potentially, if they was to go beyond their planning permission and their licensing, then potentially both of us could take enforcement action.
Lovely. Thank you both for that. That's excellent. So at this point, is there any other party who has a question for the licensing officers? We will obviously be going round and asking or speaking to you all individually anyway, but this is, in relation to what the officers have just discussed. Are there any questions there? No? Okay. So we'll now hear from any other persons present who have made representations. Councillor Worsfold.
Thank you very much, Chair. I'm disappointed to be sitting here as a ward councillor, having not been consulted by the club at any stage about this application. Neither has the very large, active local residents association been consulted, nor have the residents who live in immediate proximity to the ground. I find that very disappointing. The Flint Community Hub is exclusively a facility for children and young people, and has been largely welcomed by the local community. Let's make that very clear. People like the idea that young people are going to be able to engage in sport in a green space, in a part of Shenfield that is being very heavily developed, as the members will know. And the youth facility aspect of this has recently been reinforced by Hutton's own community partnership with Shenfield High School, underlining that this is a facility for children and young people. And again, there's a lot in that is very welcome. So the panel must view this as a youth and school facility, not as an adult social centre. It's a youth sport facility. So to promote long drinking hours at a youth facility, I think is totally inappropriate. Given the many problems frequently reported with parental behaviour at youth football matches, there should definitely be no alcohol served before or during any matches or training sessions taking place at the Flint Community Hub. My long connection, and members will know this, with the world of football has allowed me to visit many facilities, and I have never seen a youth facility, either an academy run by a professional club or a large dedicated youth facility run by a community club, that has a bar attached to the facility. I've never seen it, and I don't think I want to see it here. There's nothing in the proposed conditions about where alcohol can be consumed. If the licence is granted, it must be restricted to the clubhouse. Having people standing around a pitch at a children's football match holding pints of beer is wildly inappropriate. And the licensing policy that Mr Leonard referred to states at paragraph 22.6c that the application should cover this. It doesn't. It's silent. It also states at 22.6e that it should specify the occupancy capacity of the premises. It doesn't. It's silent on that. Paragraph G of the same clause also says that a wind-down period should be specified. Again, there is nothing in the application. And this shows to me that the application is incomplete and should be referred back to the applicant. If you are minded to grant it, I do urge you to place strict restrictions, as I've set out, to restrict the provision of alcohol while there are children on the site, while they're playing football or training. And there should be no question of including an outdoor bar as part of this licence. It's mentioned, but it's not detailed. The application also attempts to slip in permission for a summer ball with a marquee. This should also be rejected. Exceptions can be made for tournaments, as they had at their opening, nearly 2 years ago now. But they can apply for occasional event licences to cover those sort of activities. It doesn't need to be hidden in this application, which is what has happened. And frankly, the timing is also bizarre, not least because, as we've heard, it can't be used if you granted it in full. The current planning permission has an explicit requirement that all vehicles and people are off-site by dusk, as you have heard. And I do understand the need to keep planning and licensing separate, but I did detail the complications this will cause in my written objection, which you have copies of. If sometime in the future planning permission is varied, then you'll have vehicles leaving the site late at night, and they'll be shining their headlights straight into the bedrooms of the houses opposite because of the slope that is designed into the exit. As cars come up, their headlight beams will be raised and they'll hit the first floor of the houses opposite after 11 o'clock in the evening. I don't consider that to be acceptable. That to me is clearly a public nuisance as specified by licensing law. And it frankly will give rise to an endless stream of complaints from residents. Do we really want to be burdening officers with that? Security is also an issue. The site is not secure. There is a dog walker who regularly accesses the site, and there have been 2 or 3 occasions when local youths, if you want to call them that, have got onto the site and have been kicking a football round late in the afternoon, early in the evening. The music is a concern. The clubhouse is a prefabricated building and frankly is unlikely to be especially well soundproofed. Because of its proximity to the houses, any loud music would almost certainly cause a nuisance to residents. If a music licence is granted, it must come with strict conditions about noise levels, keeping windows and doors shut. And I would also hope that our licensing team check that premises have the appropriate Performing Rights Society licences for playing recorded music in a public venue. This should also be a clear condition. It's worth noting that the club unilaterally decided to locate the clubhouse in its current position in contravention to the planning conditions that were extant at the time, that have since been varied. But had they stuck to the original plans and located the clubhouse by the car park, it would have been further away from the properties and thus less likely to cause a nuisance if music was played on the premises. But that's a rod they've made for their own back by putting it much nearer to the nearby houses. So unfortunately, the possibility of causing a public nuisance is regrettably very high. Finally, please remember this is a facility for children and young people with plans for an extended partnership with Shenfield High School. If a school was applying for an 11 to 12 hour alcohol licence for its playing fields, would you grant it? Because that is in effect what you're being asked to do today.
Thank you, Councillor Worsfold. I don't think we have any other objectors. So do members have any questions of the objectors at this time?
I think I'd rather hear the applicant's statement.
Likewise, yeah, with Councillor Davies on this.
Okay, thank you.
Straight to the applicants.
So do any other parties have any questions for the objector at the moment? Again, in regards to what's just been said, we'll be coming around to you shortly for other bits. Any questions? No? You'll have your opportunity to make statements and everything else like that, so you may maybe address any issues at that point as well. You know, it's up to you. Yeah, no problem. Thank you. So we'll now hear from the applicants. Mr. Bone, Mr. Clark, Mr. Hall, Mr. Henderson, with this statement. Sorry. Yes, feel free to make a statement. Absolutely, no problem. Thank you.
Good afternoon, and thank you for your time today. There are, for us as a football club, there's a few items here that we need to just put out there as a statement. First of all, we are surprised, obviously, that the... Sorry, let me start again. Right, so the Football Club have applied for a licence, a music licence and a licence to sell alcohol at Flint's Community Sports Hub, Chelmsford Road. Item number 1, the club during the process does not actually require a music licence. It was a tick box that was put on the form by mistake. It's not an actual requirement for the football club to play music at the venue. We're not an entertainment venue, we're a small football club, community football club. Secondly, to note, the hours of business split on the application were determined wrong by Mr. Boehm, unfortunately, at the time. He sort of read the document, the fact that could be potentially our opening hours, which may differ from the hours that we actually need a licence to sell alcohol at the premises. So we're happy for that to be amended to the actual requirements that would suit the football club's current activities on the site, which will basically be running from probably the hours of 12 o'clock on a Saturday, and I'll state this time for now, but 11 o'clock on a Saturday evening, 12 o'clock on a Sunday till 9 o'clock on a Sunday. Again, these times will be currently be determined by the dusk planning condition, which we have to adhere by, and the club will honour and adhere to that planning condition. We have no intention of going against that. Again, the opening times may differ from the licensing hours, so we may be open on a Sunday morning from 9 a.m. And we may close at 5 p.m, obviously depending on light. We may not be serving alcohol in that particular day. It might be that we have youth matches and there's no reason to sell alcohol in that day, but then we just like to have the opportunity to do that. Again, on the Saturday, that's exactly the same. The only other time we do need to potentially open the clubhouse will be if we have an AGM, which we have yearly. But again, if we can do that on a temporary licence, we can. There's no issue for the club to do that. And we have trustees meetings, which we hold once every quarter. Club trustees, we have to have a meeting once every quarter. So again, Presentation Day, which is a club event, which we again hold yearly. That's probably in May. May, June time, but that's for the whole club to come together. So that will be an event that we will probably do a special licence for. Just to note, Hartlepool Football Club has held a licence to sell alcohol for nearly 40 years at our site in Hall Green Lane. which I'm sure some of you are aware of at site. The club have held many social and essential fundraising events for our members during this period. So within this period, we've had no issues, we've had no complaints of noise, disturbance, antisocial behaviour, and we've always respected and understood the responsibilities that the licence requires. We're also fully aware of our duty of care towards the club's members, our younger club members, and other clubs in the area, such as Brentwood Town Football Club, Herongate Football Club, Shenfield and Hutton Cricket Club, Brentwood Rugby Club, who all have young members, youth, playing cricket, playing football, playing rugby. There is a social element to all these football clubs, cricket clubs, rugby clubs, that are fully respected by them, and they operate on a weekly basis, as we have done for 40 years, at All Green Lane site with no issues. So we see that there is no reason for us not to continue in the way we have done for the last 40 years, providing football for our members, providing a social space for our members, providing an opportunity for us to fundraise, for essential fundraising for the club, to continue our activities going forward. We see that there's no issue with that. The club are fully aware of its obligations to the surrounding planning conditions, and we obviously be fully respectful for our neighbours. The site entrance has been mentioned, but I mean the access has been constructed as approved by Essex Highways. There is CCTV installed to the site. The boundary is now secured with fencing all the way across the site, which we were waiting for the money to do that, which is now done. So there is no issue with access to the site. The club will have responsible and trained management during the hours of operation of the premises. And just to close, we are a highly regarded and respected community football club. And as I said, we've held an alcohol licence for nearly 40 years, and we see no warranted reasons for residents' concerns and objections. That's it.
Lovely. Thank you very much for that. Do members have any questions of the applicants? Councillor Davis.
Thank you for that. Thank you also, Councillor Worsfold. I think there's some mixed messages coming through here. As you just said yourself, the hours maybe you put forward in the application aren't actually what you're really looking for and requiring for this site. And I think that's when you're sitting and you've got the information, as the residents would have seen this as well, I think it is confusing, because immediately some of the questions that came into my head, which are probably not relevant, are it sounded like a club was forming, a social club was forming. Were you going to have a bar manager? So that's a question. Do you think it would require a bar manager to manage the level of activity and the hours that you were potentially requesting?
Essentially requesting,
Would you mind using your mic just in case?
Yeah, so as I said, the hours requested on the initial application aren't actually what the club required. That was an error on the application. So, yeah, I understand your question. So, yeah, in terms of a bar manager, there'll be responsible people involved when the club is open. You know, if it had a licence, as it has done, and it operated over the last 40 years, there's always a responsible person that is, you know, going to be running that during that period, yes.
Thank you, Mayor. Thank you.
Please.
I think this is where, you know, we're not starting off on the right foot here, because immediately in my mind I'm envisaging something on a much bigger scale than actually you're really talking about, which is probably sending very much mixed messages. I was also thinking, would there be children in that bar? Because it's not a huge area. So if you were going to have 13 hours of opening in a day, you know, would there be children in that area where adults are drinking, or would it be separate? I mean, how do you envisage managing? You've done it before, obviously. How has it worked for you in the past?
Well, obviously the area is a space that's got a kitchen area, which will be serving coffees and teas and cakes and stuff like that. The bar is part of the same space, so in terms of segregation, the same as any football club or any cricket club, there is no segregation. Any pub, it's a space that is used by the parents who obviously are responsible for their own children. And the children aren't turning up on their own. We're not, you know, the parents are there. They're in charge of their own children, and they will have to respect the club rules and the way the club operates.
Sorry, just one more question. You talked about, again, in the application, about a music licence, and now you're saying that that actually isn't essential to your operation. So can I have a bit of clarity on that as well, please?
I misconstrued that question as being playing music of any sort. So in my mind, it was a bit of background music in the bar area while people were in there using the bar area. Obviously, we're not going to have live bands playing, or there won't be any speakers outside projecting huge amounts of sound anywhere. The chances are we won't even play any sort of music because it's not appropriate for us. It's the only times that we may have something like that is sometime in the summer when we have our presentation day. We might have a little bit of music playing while we're doing our presentations and things, but that's something we can deal with under a temporary event notice, as and when, or if we even do it. So, no, we don't need a music licence.
Thank you, Councillor Davis. Councillor Russell, do you have any questions?
Yes, I have a number of questions actually. And like Councillor Davis, when we look at the opening hours, we envisage a totally different operation. So one of my questions would be, other than the events that you've mentioned, AGM, etc., would there be any special events that require security?
The answer to that is no. So the licence, it will be for the sole purpose of the club members to host events for volunteers, raise money. There will be no external hired events at the club.
Thank you. Do you envisage any antisocial behaviour from your members?
No.
Some of these might sound irrelevant, but they're part of a bigger picture. How will alcohol be served during matches? Where would they be served? What vessels would they be served in, etc.?
If alcohol is served during matches, it will be obviously contained within the clubhouse. It will be in plastic containers, as we have done previously. And there will be no obviously drinking outside of that club area.
Are there any partnerships with other organisations to promote responsible drinking?
We have none at present, but it's not to say that we won't be seeking that.
And have you had any alcohol-related instances in the past?
No.
Thank you, that's all.
Thank you very much, Councillor Russell. A number of my questions have been answered, or asked and answered, but one of the things that I think is apparent is that the misinformation has caused a number of people to have different views of what's going on, and Councillor Worsfold had a lot of points that were raised. One of the things from the objectors in the written objections were people saying that there was no consultation and no discussion with neighbours. Do you think that that's true from your side?
It's a difficult one to answer. I think we have in the past tried to communicate via Mr. Worsfold from our club, via Kevin Lawkins. I know there's been communication in the past. I don't know what communication there has been surrounding this. But certainly we are, as a club, we are a community football club that have nearly 1,000 members, and we are keen to make sure that further going forward we do have a better relationship with our local residents, and we'll be happy to have any meetings with them to, you know, get some sort of understanding of where we are and what we would like to do and where they sit, and you know, work together going forward, basically.
Thank you very much. I think, yeah, obviously you're all residents in the same area, so there has to be something going on there. Sorry, Councillor. 1 second, sorry. We can clarify that. We'll just clarify on opening hours. We'll discuss that in 1 second. Yeah, so I think that's a valid consideration, because if you know, we come to all of these meetings and we know where everyone stands. It's better for everyone. I think you have gone through capacity. This has been raised, and I don't believe there is any capacity information in the agenda. Do you have any ideas on how many people may be in the premises at any point?
We've got a professional fire risk assessment that's been carried out, so I'll happily get that sent forward to you if you need that, which will, I'm assuming that will determine the capacity of the building.
So I guess, yeah, Mr. Leonard, any information?
Sorry, that was one question I was going to ask with capacities. Whilst we don't set capacities on a premises licence, a lot of what's being discussed here, and particularly events and social events and award ceremony, things like that, as the applicants have said, there is the use of tents, but obviously I was just wondering on this capacity where you said it's 1,000 members or whatever, obviously a temporary event. Now, I'm sure they're not all going to turn up on the one day, and I'm sure that Porter Cabin can't host that sort of numbers, but obviously if they were looking at alternative measures for specific special occasions, a temporary event notice would only cover the 499. So would you envisage any larger numbers than that for any of these events you're looking at?
Your mic, Mr. Leonard, sorry, thank you.
The answer to that would be no. It would.
In which case, if I could just assist you and help you with regards to this, because it has been mentioned, as the gentleman said, Hutton FC have had a club premises certificate for 40 odd years, and as we've seen from Mr. Bowen, he's possibly not up with all the legislation and putting a wonderful application together. In relation to the former club premises certificate, obviously the big factor on that, although they've got the hours, the difference with that is you can deal with the supply of alcohol with a steward as opposed to a premises licence, which is being applied for here, where you will need a designated premises supervisor. In respect of this, Mr. Bowen has put himself forward as the designated premises supervisor should a licence be granted to supply alcohol. However, at this stage, and probably from what is already explained, his knowledge is not up to it, and he hasn't got a personal licence, and there is no one currently holding a personal licence. So should a licence be granted today, until such time as a designated premises supervisor is nominated, they won't be able to supply alcohol anyway. In respect of that, just to clarify matters, as you said, on the application, it had 11 o'clock every night, and I know there's been a discussion about amending the hours, because as you said, again, inexperience with the application, the closing hours was 11 o'clock as well, so there's no drinking up time, doesn't show a responsibility or an understanding of the licensing there. But with all due respect, again, it's applied for an on licence, not an on and off sale. So, as the gentleman said, all consumption of alcohol or sale of alcohol is going to be contained within the porter cabin, as opposed to taking it out onto the field, where it may be considered irresponsible if there are children playing, or it's in plastic containers. So, just in respect of that, yes, I was just interested to hear, just the clarification what hours they were seeking, as opposed to the 11 o'clock and whatever. But otherwise, we can work with them on that. But as I said, there is no current personal licence holder or DPS. And as I said, with the hours they're asked for, they haven't really dealt with the drinking up times or anything like that, which again, I'm sure you'd have been taken into consideration. The only other thing I'd look at on just having a police background, that the police have agreed things on that, to take in mind that it is a porter cabin. I'm sure it's got all the security measures, but obviously drink will be remaining on the premises at all times, and you've got CCTV. Just the reassurance is that you've got adequate security to prevent the antisocial behaviour of youngsters coming in there and breaking into it in the hours of darkness and that sort of thing. Thank you. The question, probably with the hours, we've got the bit about no more than 499, so there is going to be the opportunity to use temporary event notices for special occasions. The only other issue I would ask about, obviously, as you said, how you're going to go about with a designated premises supervisor.
Just to clarify a couple of things, if we hold presentation weekends for all the kids' teams to be presented their trophies and things like that, they're never all on site at the same time. It's done on a stage thing over probably 2 days, Saturday and Sunday, spread out over the day. So there wouldn't be 499 people there at any one time, And not half, but a chunk of the club are senior players, so they don't have a presentation day anyway. They go out for the night in London somewhere and do what they do. So there wouldn't be 499 people there at any one time. Cool.
Well, just one other thing to clarify, if an on-licence is granted, irrespective of whether there's an application for the recorded music, with the hours we're looking at, it would all come under the deregulation anyway. So, but again, as the gentleman's mentioned, background music wouldn't apply anyway. It's not licensable activity. Just to clarify matters for you.
It's all very useful. Thank you very much for that. So, so as it stands, obviously with the current application, there is a requirement for a DPS. Or do you have any plans for that, or do we need to look at what's needed there? So you need a person who's designated to be responsible for dealing with all of this and managing all of the details around having a licence.
As David mentioned, part of the naivety of me completing the form, really, in the first instance. And we didn't quite understand about this thing with licensee and stuff like that, because in our heads, we were just moving from Hall Green Lane to Flint's and doing exactly what we did there and over there. So we just thought it would just carry on as normal and everyone be happy. But the licensee, we haven't got a licensee designated at the present, have we?
No.
But part of this process of opening the new site up and opening the clubhouse up was to get somebody to be the licensee. It may be me, it might be others.
Just check with licensing officer. The licensee doesn't have to be on site, does it? They could have a licensee from another premises, might be a club member or something like that.
That's correct, sir. I mean, we've got a number of sort of social clubs where a licensee from one of the local pubs, if they're happy to nominate themselves and accept the responsibility, as long as they're in day-to-day control, they don't have to be there all the time. And I think that's probably the example. I did try on a number of occasions to get hold of Mr. Bowen during the consultation period to try and clarify some of the matters that you've very wisely picked out. And I think obviously where we have got this changeover and possibly the application form going in is that, as they've said, for a number of years, 40 odd years plus, they've operated a club premises certificate that doesn't require a licensee. And I'm sure as responsible adults and whatever, they've managed perfectly fine. I can honestly say I've not dealt with any complaints against the club premises certificate in its old location. However, again, as we look at these things here, the committee of gentlemen, they're all busy people with other jobs doing this as a voluntary basis on these things. And one of the biggest bugbears I do get in the licensing, particularly when it comes to the annual fee renewals, is that we cannot get hold of committee members on social clubs and club premises certificates because they're doing other things. So there is the question, and obviously that would have been asked during the consultation, have they really gone for the right application that they need? Certainly, obviously, a premises licence does afford them the ability to not have to work with all the rules and club premises conditions and committee rules. And obviously, a premises licence does then allow them to use the facilities for members' birthday parties or special events, which again is a good generator of funds for these community ventures. So, a premises licence with the proper knowledge is absolutely the way to go. But as we've seen there's a number of discrepancies that could and should have been resolved during the consultation period. And it's just unfortunate we couldn't get in touch. But as I said, obviously the clarification I'm looking at this is it's on premises, so it happens within the building. They can't take drink out. It'll be controlled, no doubt, as they used to do under stewards. But we have got that difference of the fact that there isn't a great knowledge from any of the committee there with regards to the Alcohol Licensing Act for premises licence, which they'd obviously learned going on a course. But hopefully that clarified the hours and whatever you wish to go with. Thank you.
Thank you, Mr. Leonard. So, I guess it raises a couple of questions. Do you feel that this is the right application for you at this point? Is this something that we should, or you may wish to revisit? I mean, I don't know. I guess we probably we probably have to make a decision. I'm guessing no matter what, but I don't know where we're at, where we would be at with that. But it would be interesting to know, you know, whether you think it, you know, it's the right application at the moment. I mean, I don't. I don't think we can't change at this point, but the point is that we're going through an application process that may be unsuitable for what you're actually after, and quite honestly, whilst we're all here and in the room, you know, I don't mind if you want, if you know, have some questions from Mr. Leonard to clarify some points about the application that you're going for. It may be of use. I don't know.
Well, Chair, the other thing I did go through with the gentleman on this, obviously looking at it, there is an expenditure. They have already paid out probably quite a bit of money for a public notice in the newspaper. Again, there will be additional fees for a one-day training course and then fees for a personal licence. coupled with the fact that every year they'll have a £180 licence fee to pay. So with all that expenditure against the amount of events they have, potentially temporary event notice would have covered them at £21. The other option being, obviously, as they've worked 40 years with a club premises certificate, that might have been the better option for them in regards to the fact they don't need a DPS. However, as I said, it's a valid application, albeit a little bit poorly put together, and in fairness to them on that, they could ask for what they have done, amended it.
Yeah, Mr. Adams.
Sorry, I think we're obviously in a situation, Chair. I think the application has been made. I mean, the application, other than the sort of the internals about sorting out who is going to be the DPS, to become a DPS, you have to go on a training course. It's a one-day training course. So hopefully that will give the person the knowledge they need to know to sort of run this type of establishment. Obviously the committee could withdraw the application now and then could reconsider and apply for a club premises licence or something later on. But obviously they've gone to a lot of time, effort and expense in getting to this position here today. And I think ultimately, what the premises is looking to do is to supply alcohol or sell alcohol to their members, around the sort of type of events that they've applied for. So I think, as long as the club are happy to proceed on that's what they've applied for. I think there's some suggestion around perhaps varying the hours they've actually applied for here and now. But I'm sure we can work with them to make sure they fully understand their responsibilities, whoever is going to be the DPS, and advise them who actually would be best placed to be the DPS in that type of premises.
Okay, thank you very much for that clarification. So I guess the only other thing then at that point is clarification on the times. I mean, you mentioned, sorry, my laptop's gone to sleep. So Saturday 12 till 11 and Sunday 12 till 9. Those are the hours that you feel would be your required operating hours that you would need to do the work that you, or the activities that you need?
They're the hours we're putting forward. Obviously, that's determined by dusk, depending on the time of year. So, which is obviously a planning condition currently on the club. But yeah, I don't see how you can grant a licence based on dusk. So you have to determine the time. So they're the times we're asking for, but that will be determined by when dusk falls.
Yeah, that's good. I mean, as I say, I was just trying to get your idea of the plans, and if you're happy with those. I know, I think you used the word "about" when you first mentioned them, and so I just wanted to be clear that those were the hours that you were happy with, that you required.
Apologies. Could I just for clarification, so you're looking to amend the licensable hours for a Saturday 12 noon until 11 p.m. and on a Sunday from 12 noon until 9 p.m. The rest of the week you're not looking for at all?
Sorry, your mic.
Sorry.
The only, as I said, we have meetings midweek, like trustees meetings, and we also have, if we hold an AGM, that will be midweek. So it's whether we do bring them hours into there to cover them off, or whether we apply for a temporary licence outside of that.
I mean, my advice would be to include it in this application, because otherwise you're going to get confused as to what you're doing. I think at the moment you're looking for 11 a.m. until 11 p.m. Monday through to Friday. Are you happy with those hours, or were you looking to reduce those hours or change those hours? Just the other thing I was just thinking about bank holidays as well. So that falls on a Friday and a Monday. So you don't want to forget about that now.
Initially, I should say, kind of just went with the general kind of pub opening hours that all the pubs and whatever use, sort of 11 to 11 kind of approach, slightly reduced on a Sunday. That's why I put those down. And at this time, of course, I couldn't put dusk because there's no button for dusk, a bit awkward trying to pitch, you know, where we need to be.
I think the suggestion is from me, you know, it's up to you what hours you're requesting, and I think it would be for the committee to make the ultimate decision based on if there's reason for the promotion of the licence and objectives to amend what you're requesting, and they would have to have reason to do that. So I just want to make sure you're getting what or you're asking for what you'd like or what you need, as opposed to sort of feeling you've got to curtail it, you know, for the sake of it.
Sorry, can I just ask a question? I, for one, am getting totally confused with this. Is it possible, bearing in mind the expense, and I understand all that, and the fact these gentlemen are professionals, and this is not something that it's natural to them, to have a deferral for this actual hearing? Because I think we need to know in black and white what we're actually discussing, because we seem to be making it up as we go along at the moment, and it just concerns me, Tad.
So, Lucy, happy with that? Before we do that, I know Councillor Worsfold has wanted to say something, and we've kind of gone a little bit outside the normal process of this. So, yeah, I'll listen to your...
My questions would help your conversation about clarifying what the hell is going on here, because I'm completely baffled. I feel I've objected to a completely different application to the one that's now being discussed. I feel that the residents have objected to an application that is now going to be completely different to what you're about to discuss and potentially agree. And I think, personally, I think that they should be consulted properly on whatever is formulated here. So I'm baffled. So firstly, can I just clarify, because this might help you, is the application for a music licence now being withdrawn?
So I guess the point is that it's down to the applicant to make their decision.
These are my questions.
They have advised that it's not required, but they still in a position to request it. It's part of the application as it stands. And so if we adjourn, we can get clarification on exactly what is being requested, and then come back, and then we have you'll have a good understanding of what's actually been asked for.
Can I follow up the point about the weekday opening? Because my understanding was the request was for Saturday and Sunday licence, but not for a weekday. I mean, if you have an AGM, you can have tea and coffee, or you could apply for a special licence. And I do want to say one thing to put on the record, that the events that have been held there have been well managed. The opening day tournament was extremely well managed and was very successful. And when the club were holding, you know, the regular matches last season, they managed the potential issues with people parking on the verges extremely well. And all the residents are very grateful for that. On the consultation, because it was mentioned that Kevin Lawkins had discussions with me, and that I have been in touch with Kevin on many occasions. The week before this application was put in, I was talking to Kevin about, why haven't you been playing matches? And obviously he explained to me all the drainage problems you've got, which are unfortunate result of the very long dry summer. But not once was I told that this application was coming in. So the first thing I knew about it is when residents are on the phone to me saying, what the hell is going on? No. Where has this come from?
Sorry.
So, yeah, I wanted to put that on the record, because it was mentioned that I was having conversations with him.
You will
Those
have a
are the
chance
conversations. That was what was in the conversation, and that was what was not in the conversation, which is why I said at the beginning I was disappointed, and I think I'm entitled to be disappointed.
Councillor Worsfold, thank you for that. You will have a chance to sum up later on. Anyway, you will have another opportunity to speak. So, but I think the 15 minutes adjournment would be very useful for everyone to work out exactly what is required and come back and make things clearer for everyone. Then we can hopefully make a decision based on what's put in front of us. Is that okay with all?
Agreed.
Yeah. Agreed. Great. Thank you.